Alrighty, just a quick reiteration here. Unfortunately, with my last video that I just recorded and uploaded for you all in regards to the AMG report and the latest MedBed report, connecting the dots, so to speak. Unfortunately, at the end of that video, for some reason, the audio did not play in regards to the FDA, the Supreme Court versus the FDA and the Chevron document overruling of the FDA's way to be able to interpret what is medicine, what is not, and what is medical healing technologies to be brought out to public domain and what they cannot. Okay, so what I've done is gone and done this new video here and reiterated here and play for you now that particular video that did not play the audio for you just before. Okay, so I hope you enjoy it and gives you a better idea as to how the actual Supreme Court is actually stepping in such a way that is allowing and paving the way for these medical technologies to come through to the public domain without the hindrance or interference anymore from the FDA in America or eventually within Australia, the TGA. So check this out, everyone. I hope you enjoy. I hope this informs you as much as it informs me.
We were all looking at the Supreme Court's decision on presidential immunity last week. Due to the immunity opinion in Trump's favor, the sentencing for his 34 insane convictions has been delayed until September. That was the big news last week. Well, SCOTUS passed down another opinion last week, which is just as important as immunity, but nobody is talking about it. The recent Supreme Court opinion on Loper Bright Enterprises v. Raimondo effectively overturned the Chevron doctrine, which is a principle derived from the 1984 U.S. Supreme Court case, Chevron USA, Inc. versus the Natural Resources Defense Council, Inc. The Chevron doctrine directed courts to defer to a federal agency's interpretation of ambiguous laws that the agency administers. Why does this matter to us, you might ask? If you've ever read FDA laws related to energy medicine, you'd know that the law couldn't be more confusing. The medbeds of the future clearly fall under the category of energy medicine. The best clarification of the regulatory enforcement for energy healing was issued in a February 2007 guidance document published by the FDA. The guidance document concludes that various CAM therapy or practices may be subject to regulation. Such language really does little to clarify energy devices, and it was produced by the agency, making this guidance moot now. Had the Chevron doctrine not been contradicted, officials of the FDA would have had the authority to interpret the law in a way that could stop the use of the medbeds of the future. Now, before you repeat the narrative that the military is in charge of medbeds and all current laws are just going to dissolve, you must realize that while the military might initially oversee the use of the beds, they do not have the authority to violate, change, or interpret FDA law. The SCOTUS decision just removed the FDA's ability to unilaterally decide that medbeds must complete a new medical device application and go through the approval process.
As all
if the
things
FDA does attempt to impede the distribution of medbeds, they can't do it without a decree by the courts, effectively making it much harder for the FDA to stop the medbeds. So previously, federal agencies were able to interpret ambiguous statutes. The agencies are no longer able to make such regulatory decisions without due process. This significantly impacts the regulatory landscape because the ruling shifts the power to interpret laws back to the judiciary, limiting agencies' power in implementing complex and technical regulations. Without Chevron deference, courts will no longer defer to agencies' expertise in interpreting ambiguous laws. Opponents of the decision say that this decision could lead to legal uncertainty and challenges to regulatory actions. They believe that future technological advancements may face hurdles as judges, rather than specialized agencies, will decide on regulatory interpretations. But the reality is that the regulatory agencies no longer have such all-encompassing power over energy healing due to the lack of clarity in. So now the game has changed, and the FDA's wings have been clipped, so to speak. Why should you care? Well, think about cutting-edge medical tech like off-world medbeds. These futuristic devices promise to revolutionize healthcare, but without the Chevron doctrine, the path to innovation is no longer impacted by agency interpretation. So, tech innovators, buckle up. The landscape of medical innovation for complementary and alternative medicine within the National Institute of Health has classified energy therapies as a category known as CAM, or complementary and alternative medicine. The SCOTUS ruling
This is what's
emphasized
coming.
that it is the role of the judiciary, not agencies, to interpret the law, especially when the statutory language is unclear. So the bottom line is that FDA will no longer have the power to march in and shut down medbed centers in the United States without due process. It's the little things that sometimes make the difference, and there are a lot of little things going on in the background. I wouldn't be surprised if a clarification of energy medicine occurs in law, and I'll be watching for that. So things are looking up, and hopefully we will be stepping into a whole new landscape of healing in the very near future.
That's pretty reassuring, don't you think? Mate, gives solace and reassurance to me, knowing full well that this is coming through and that the FDA and TGA will no longer have the ability to determine or interpret what is going to be coming into the public domain for our benefit. They can no longer reap the rewards of using us as a cash cow to keep us sick anymore by their petroleum-based and oil-based pharmaceuticals, okay? And the Rockefeller Foundation, Big Pharma, et cetera, eventually will see their own demise due to the fact that the snake is eating its own tail right now. So I hope that you've been able to enjoy this informative, quick update, reiteration of a previous video that I showed 3 months ago. Well, actually, yeah, what are we now? November. So August, September, October, November. Yeah, 3 months ago. August 13th, I believe this original report first came out through Medea. I'll just quickly go up and check for you. Yeah, 13th of August, 2024. Good memory. There you go. So this is a 3-month-old report. So it proves now that this Supreme Court pretty much has bombed the, as it says, boom, bombshell to the FDA. And you can bet your bottom dollar, as I said earlier in the other video, that you can say that that will happen and trickle down here to Australia, where the Supreme Court here will eventually rule against any form of documents that are in the way of the TGA interpreting and determining what is energy healing medicines, or CAM, complementary alternative medicine, okay, coming into the public domain, such as med beds and alternative therapies. Okay, they don't have the ability to do that. They're being cut off at the ankles, okay, and their wings are being clipped, and this future is rolling out one way or the other. Okay, so take solace, take heart in knowing that this is coming. Mr. Trump said within a year or so, all hospital procedures will be obsolete. So what does that tell you? I love it. So thought I'd just give you that reiteration of that video that you missed out at the end of my prior video, so that you could hear for yourself the audio. So saying that, I say goodbye now, everyone. Take care. I'll see you all next time. Love you all.